Good morning, everyone, and thank you for joining us today for a CaseMetrix webinar featuring our client, David R. Williams. David is principal of the firm Williams & Williams in Columbia, South Carolina. He is well known for his record-setting verdicts and settlements, and he has significant experience handling big cases of all types. When I think of David, I think of these big, monstrous verdicts and settlements. He has brought in hundreds of millions of dollars for his clients. He focuses his practice on civil litigation, and he continues to handle cases involving things like serious injuries, catastrophic injuries, death cases, trucking accident. He also handles toxic exposure cases, things like spinal cord injuries, drunk driving, dram shop kind of cases. He also handles elder abuse, child injuries, electrocutions. In fact, he has a $90 million verdict in Orangeburg County, South Carolina on an electrocution case, which is by far the largest verdict ever reported to CaseMetrix in a case of that nature. In particular for that county. If you have cases involving things like negligent hire, negligent training, negligent entrustment, anything from dog bites, med mal, unfair trade practices, birth injuries, a lot of TBI things. So you can look at his website and see a lot of different things that he handles. You'll find a number of David's remarkable 8-figure cases in the database, including that $90 million verdict I talked to you about in Orangeburg County. During the webinar, I'm going to post David's contact information in the chat. So if you have a case you want to contact him about, you can do that privately after the webinar. And for questions during the webinar, please log those in the Q&A, and I will read these to David. Today, David is going to share his expertise with us on how trial lawyers can increase profitability using technology. So David, without further delay, I'm going to hand it off to you, and thank you so much.
Kim, thank you for having me. Obviously, I've enjoyed working with you over the years and learned a lot about through the tool that you provide in CaseMetrix, and it's certainly a valuable tool for us to understand, the nature and value of cases in different jurisdictions, and gives us a lot of grounding to aim to achieve, to exceed, right? I mean, I call me the sucker, but I look at it as where's the line I want to cross to go up, right? And all seriousness though, I'm here today because I'm very passionate about the use of technology. I gave a talk earlier this week on at a CLE that I was actually filling in for another lawyer, talking about how to ask for money in a closing argument. And I had like 2 days to prepare my thoughts on how to teach folks to ask for money in a closing argument. What's important about delivering that in a plaintiff's case? Well, it all really boils down to one thing that separates great advocates from mediocre to poor advocates. Is presence, right? And presence doesn't mean that you've got to be Perry Mason and you've got to be, name your best storyteller you've ever met. It means how you present yourself, and more importantly, how you let the focus be on someone other than yourself, right? And I've found in my practice, for a bunch of reasons, presence is largely with technology. Technology gives me certain, insecurity breaks where, hey, if I get stuck in this storytelling, I can revert back to this image in my closing argument. I can revert back to this video clip. I can get a breather if I need it to be more relaxed and more deliberate. If I had to criticize myself in my closing argument, is I wish I could control my tempo. I listened to, I don't know, I was watching a movie and I listened to FDR's speech after a very important event. And, he gave a speech that couldn't have been more than, or at least what they played in the movie, couldn't have been more than 50 words that lasted half an hour, it felt like. But it was very deliberate, long pauses with intentional infliction of thought to certain parts of the sentence. And I wish I was better about that. I wish I had more training on that. I certainly want to practice that. But I think that the reason I've had better results than most in trial is use of technology and use of telling stories, not just with words, but with images. And as we increase our number of the population that spend more of their day behind a blue screen, the more it becomes necessary to even get your story across. I mean, I don't know out of this group how many of y'all have tried a case where a juror was asleep during half of the trial, and certain presenters, they probably caught zero information from that presenter. So when someone was giving the closing argument and referencing certain testimony or a certain exhibit, they didn't even see it. I mean, they don't know what you're talking about or how it plays into the case. Well, technology fixes that, but guys, I'm not here just to tell you that you need it for your closing argument. The problem, I think a lot of lawyers, and I'm guilty of it, Kim says nice things like I work these mega monster cases. Well, I work plenty of smaller cases too. I live in Orangeburg, South Carolina. In Orangeburg, my jury pool wouldn't be very tolerant of me if I wasn't here to help people with ordinary problems. It can't just be $100 million problems. It can't just be $50 million problems. It can't just be $10 million problems. It can't just be $1 million problems. There's plenty of times that I'm doing cases that are much less long-term, benefit to my paycheck, but it's still helping people. And I didn't get in this business. And the other thing about presence is I think people can recognize the folks that do it just to make a dollar, and they recognize the folks that do it because it empowers them to make a change or it empowers them to help someone. That presence is absolutely necessary. Well, you all know, I mean, how many of your cases go to trial? Less than 1%. I mean, 0.5% if you're aggressive like me. If you're not aggressive, I mean, what? 0.1%, 0.001%. I mean, it's so few cases that are going to trial these days. Because in today's environment, I mean, look, we've got this great product, CaseMetrix, that people can get an idea what a case is worth. They can get a range. There's more solutions like what. And look, I'm not saying that I don't want more cases tried. I think the trial is certainly a very, very important role, but because of the information systems now, people, I mean, there's AI that can be an evaluator. I'd love to see the case, the bad faith case I file where, my reasonable basis is AI told me that this case was only worth between this range. I look forward to that. That'll be fun. I mean, there's differentiating factors in every case that I'm going to talk a lot about how technology can help you with that. But we got a lot more basis to get in the same range, to cross our ranges, right? I mean, in essence, that's what settlement is. I mean, how many of y'all have been to a mediation where the mediator told you, really, if everybody is unhappy, I did a good job. And if the range is crossed, basically, I mean, you set your range here, they set their range here. If this and this don't align, it's harder to get it resolved. But you know what? If they cross, it's easy, right? It's a foregone conclusion that you're going to resolve that case. What I want to tell you is how to set the line that is not this one that's yours initially, but this line, their evaluation of your case by the use of technology, where look, if this is your range and this would be your range with their range without technology, I'm going to make this their range using technology. And the reason why their range is always different than yours isn't because they don't understand the medicine. It isn't because they don't understand the facts regarding liability. It's usually because they don't understand the human element. They don't understand the non-economic damage element. They don't understand that what motivates jurors is breaking the golden rule in their own minds. No, we don't say, put yourself in their shoes, but you put them in their shoes, right? You're trying to get a jury you're empowering them to react for a person that not what they need, but what they deserve, right? We're not here to get just what our clients need. I want what they deserve. And what they deserve is a lot more than what they need. And at the end of the day, I hope y'all like what I'm showing you. And if you don't, it's important that you understand why you don't like it, right? Everybody, I'm about to geek out on you, and I understand that. And everybody doesn't like to geek out like I like to, right? Everybody doesn't love technology and like trying new things and want to take with their free time experimental things. That some of what I'm going to show you is even new to me, right? I've been experimenting with it before I employ it in a bigger case, because if you work big cases, it can't be trial and error in a big case, right? You've got to have a plan and you got to execute. So I'm gonna show you some stuff that's like the latest thing that I'm employing now in my biggest cases, right? And when I say employing now, this screen you see behind me, this is a new toy that I've been playing with for 4 or 5 months that I'm trying to make sure I can execute, repeatedly. I'm that guy that I show up in the courtroom. Every screen in that courtroom's got redundant connections. I'm not going to be the guy that fuddles around and I can't present, or I got to stop to fix technology. I've always got a paper version too. I've got a notebook that has every exhibit in paper form too. But the idea is, with the redundancy, with certain steps, with certain testing, that you don't run into problems. But I get the fear, right? I get the fear. I get why some people want, a hot seat, an attorney or an IT guy that's going to sit there and run the technology in the courtroom. But let me tell you, the courtroom's not where you start, right? You don't start by doing these exhibits and putting this information together in the courtroom, because if you do, you've lost tremendous value for your client. You've lost tremendous value. You hadn't gotten them what they deserve. You got them maybe what they needed, but not what they deserve. And what they deserve is that you put this stuff together before you make your demand, that you put this stuff together immediately when they want to play the game, because you got to make it a cost to play the game, right? And you got to show that you're willing to put the work in on the front end, so that you know what, the game's over before they began, before they really got in the game. Okay. I'll start by telling you a couple little pieces that I use. Smokeball is my software that helps me manage divvying up tasks, divvying up workflows, building out templated workflows that tell my staff, like Randy's on this Zoom right now, working remotely, and it gives her an idea. Like, here's what you do in a trucking case, right? Here's your templated letter that goes out for your spoliation letter. Here's your templated reminder to consider consulting these different experts on these particular issues. Here's your discovery that you need to send out in this case if we file suit. Here's your timeline from the point where we realize we're not getting it resolved, which seems to be never pre-suit, to the time that we file suit, and what we need done prior to that 90-day before mediation mark, that 120-day before mediation mark. And let me tell you, if you do all this after 90 days prior to your mediation, you're not getting your clients what they deserve. You're giving them what maybe they want, but not what they deserve. So I build out my file, right? And stuff comes in, and that's my storage place. And what I use, and it doesn't mean you have to use this particular software, but I use primarily, for quite some time now, I've been using this program called OnQ. Now, OnQ is pretty aggressive for a lot of folks, and I'll share a screen with you, but this program is pretty aggressive. It adds a lot of different features. It's got a media bar that allows you to build out and plug in different documents that are either JPEGs or PDFs or whatever. Converts everything to like a TIFF file or some kind of video file or some kind of image file. And then you can plug in videos. You can plug in your transcripts. You can create designations. It's got pretty neat designation wizards that I'm going to show you. And then you can build out media scripts, which were like PowerPoints, right? So, I've got one, how to create exhibits properly, how to, demanding money is how to use this to create the ultimate now, what I've been doing in the bigger cases. I want to do it in all cases, but I'm making my demands, and listen to this, I'm making them via video. Now, why, and I'm gonna stop sharing this for 1 second. Why is it that I'm making my demands in a video format in big cases? Because in the cases where those non-economic damages, when the cases involve the story that you tell, the day in the life, the flow of individuals who are affected by the loss of this loved one, or the injury of this loved one, or involved in the daily care of this loved one, or those type cases, let me tell you, it's hard to get an adjuster, a round table, some manager to open that document or that video. I found myself, I was spending $10,000 to $15,000 on some of these videos, right? And I didn't have any assurance these people were even watching them. And sure, I worked with other lawyers when I was younger who would just get up and hit play to a day in life video at the beginning of a mediation. Well, let me tell you something. If you're trying to change the number at mediation by playing a day in life video, you've wasted your time. That person doesn't have the authority to go in and, oh, I now recognize this isn't $1 million case. This is a $50 million case, right? I mean, they can't do that. I mean, it's just not the way it works. And that might be an exaggeration to the change that video has, but let me tell you, when I put this video demand and it begins to show clips of very particular depositions, when they can see the live exhibit that the jury's going to see, when they can gather how I'm going to put it together in a closing argument, boom, I'm going to prove this with your 30B6 deposition. I'm going to prove this with your driver. I'm going to prove this with your expert. I'm going to prove this. And you show them how that's going to play out. Sure, you're probably showing too many of your cards, but you can still hold some back and do that. But let me tell you, they're seeing that, and let me tell you, if the demand has, they don't get the number in a letter, they don't know what the number is, they don't know what the ask is unless they watch the video, and you put that thing in there in the middle of the video, and they've had to watch excerpts of your day in life video, and they've had to watch and hear the people that are impacted to be able to hear the number. And when the round table occurs and that adjuster says, well, I've got this hour-long video demand. I can try to summarize it, but you probably need to watch it yourselves. Let me tell you the effect that has. You get a lot more money. And I'm not telling us to brag on it, right? But I've done now 5 or either 6 different video demand in cases, and this ought to tell you everything. There's a reason why I can't just hit play for you on one. Every single one of them, the condition is that video remains confidential. That video, we don't want that getting out to anybody else. This company does not want that being released. We don't want anybody to see it. We want that video to go away in your file and never see the light of day, right? Because it paints that strong of a picture, culpability. It's the kind of video that will give anybody, motivation. The most conservative person, the motivation to go empowered that something needs to change, right? I mean, it needs to change because those fine people that I just watched there don't deserve this, and the fact that it can happen to somebody like that, it should never occur again. And when that happens, look, I wish I was more aggressive. I got a good friend who's one of the best lawyers in this state, David Yarborough. And David, we worked a case, this elevator case that was a very tough liability case, and I think it's in Kim's CaseMetrix, but we ended up settling it for $20 million. I think it was 20 million. And we almost didn't settle it because of confidentiality, right? And David's like, well, hell, I'm not going to take, I have a hard time. I mean, it's a hard thing for me to go to my clients and say, I really want to be able to talk about how good I did for you to other folks. And I'm not saying this is why David does this, but for me, I mean, I think David does it because he wants it to be public record. He wants it to be, hey, somebody else is going to know about this if you do this again. But I feel like I use it more for like something like this, where I want to show you, what I did, how I did it, because I'm proud of what I did. I'm happy with how I did it, and I find David very strong to be able to refuse to do that. And obviously, he knew what I suspected; they were still going to pay. But ultimately, I'm eating up a lot of time talking about this process, and I need to show it to you, okay? And I need to show you how I'm changing my process some. So, as I do this, and again, you can do this with PowerPoint if you don't know how to use the snippet tool. So again, just snippet. I mean, the snippet, if you go into the search bar on your screen and type snippet, you're going to see where this app is going to give you access to just put a lasso around anything, cut any picture out, any text out, or whatever you want. You can do that and plug pictures in Paint and modify them, plug them in a PowerPoint, whatever. this is just best for me because it gives me redundancy. I can print barcodes at the bottom of exhibits, and well, I didn't mean to get to that one yet, but I'm gonna be doing things where I can publish them easy, where I can edit them on the fly, where, if I've got this exhibit right here and I want to live, or right before I publish it to the jury, I want to zoom in, or hell, if I want to, move stuff around, I want to highlight something, whatever it may be, I want to highlight this, I want to, you name it, I can do it and save a quick image of my edit. Is why I use this. It's just a little bit faster for me, a little bit more complete for me to edit these things. I can go through these, all my different items, and if I've got like a very particular item, I can come in here and I want to get that line out of this contract or whatever. It just gives me access to that quicker, faster, and I can quickly modify something on the fly if I'm in a deposition or I'm in a trial or wherever. Now, why am I creating these exhibits? Is because I'm going to use them in a deposition, right? I'm going to use them in my demand. I'm going to use them at trial if it doesn't resolve. Too many people don't create exhibits that, for their deposition. So again, some exhibits speak for themselves though, right? I mean, how do you not play? I'm gonna play this video right here. And so I'm gonna publish this video, ignore that screen there, but how do you not play this? I mean, what do you need besides an exhibit like this of a tractor trailer? Oh, he's over the right line right now. You can see he's not even centered up on the road, just trucking along, about to hit the rumble strips here. Just watch this, going 67 miles an hour, cruising along. By the way, you heard something on the radio, turned his CB off a little while ago. Look at this. Watch this. Does he ever touch the brake? 66, 67. I mean, you don't need to be a rocket scientist to know that's just got to get played a bunch of times in that case, right? This is a pending case. This hasn't gone to trial yet. Comes up for trial, I think in May, but in that case, in the driver's deposition, he says he turned his CB off. What's important though is that he'd given multiple statements that over the CB, people were warning him that traffic was stopped ahead. But what did he do? He turned it off, and there you go. But you create these exhibits one by one, and you start with, here's the ultimate, post collision thing. But again, what is important about an exhibit like this, right? It depends on the deposition, depends on what we're trying to establish. On this one, it's talking about the need for an escort vehicle with a wide load. So, what are we looking at? We're looking at this overhang. We're looking at, we know the width of this particular trailer. Well, using some technology, we can zoom in, we can go and find scales. I mean, I'm sure we have certain dimensions and we can lay out like a mock ruler on this. We can come in here and, lay down, some kind of tracks to be able to put a line here and then, write out the measurement of what that line is. That's what creating exhibits, why it's important. Then we go to the other side of that case, and here we are, with this vehicle, and we see these trusses here, right? And again, we know that this point over here, is the other side, 8.5 of that. We know we have that other distance hanging off the other side. But why do we have this car, which we know how wide this is? Why do we have this? How can we not get an idea how much wider this is from that trailer there, right? May not be the scientific certainty, but it can be used to tell a story. It can be used to tell a story that if again, if we zoom into these things and we look at these pictures as a whole, and we know the law that requires an escort if something's over 12 feet, different kind of escort if something's over 14 feet, multiple escorts if something's over 14 feet. And, we go and I guess, we know things we can pull from the World Wide Web that, we know 72.9 inches is more than 6 feet, right? We know how to add 8.5 plus 6, right? And so, we make an exhibit like that, right? We know this vehicle is only 6 foot. We know that trailer is 8.5. So even with just this overhang, seeing that that's wider than this vehicle, we know it's over 14.5 feet, right? But, we ask those questions about that wide load, and people don't want to acknowledge escorts required. And then, you show this overhang, you show that image, and clearly should have been an escort. Well, can anybody say that this would have happened, that video you just watched? Would this have possibly happened if you had an escort in front of that truck? If you had at all times two-way radio communication between the truck and the escort? Theoretically anything could happen, right? But by golly, you would hope that it's a 99.9999999% chance that it doesn't happen, right? Things like this, like the policy of that company, right? So, if I'm wanting to call out something very important, live in a deposition, now I want you to think now. Historically, you take a deposition, you hand a piece of paper, and they attach it to your document, or you refer to it in the video deposition. But technology is a wonderful thing. Videotape your deposition, add a Zoom link, ask the videographer to also record the Zoom like we're on now, where you see my screen. He can pin the witness in the corner where they still see the witness. And you know what the jury can see? Live, you annotating this thing, you bringing out the safety policy on this particular issue, you focusing on this utilized escort vehicle to spot ahead for obstructions, right? This is the primary directive for all commercial drivers for this company. And then what you got here is you save that image, right? That image is on the screen, you save it. It's already been created in front of the jury, right? So if they try to back up on the testimony, or you decide to publish, that witness's deposition, if it's a party, say it's the 30B6 of the safety director of this company, you publish this. I did this with their expert a week or so ago, and you publish this video where the jury saw it being created. Well, let me tell you, when they try to argue all during the trial, they weren't required to have these two escorts, that this was the interstate, that this was actually only, at most 12 feet wide or whatever, and blah, 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 whatever the excuse may be. And you've shown it to them. And again, I've even got the load sheet that shows the if they did it perfect, they could have made it 13 feet wide, right? So they got problems all day. And we know it wasn't perfect, but we know that it didn't say commercial drivers carrying a load between these widths, get an escort, commercial drivers carrying a load over this, don't get it, or under this, don't get it, get it. It says all commercial drivers utilize escort vehicle to spot ahead for obstructions. Well, let me tell you, if that's such a key point in the case, which it is, this is their own policy. This is their own procedure. How do you argue all day? What it does is empowers the jury to say, you know what? I'll tell you how we fix this. We fix it with a number. And it doesn't just become about, what my client needs. It gives my client what she deserves, because she's going to get the benefit, and they know it, and they recognize it now. She's going to get the benefit of the jury being empowered to change them. This is the actual one from that case. So this is a live exhibit in that case. This is an exhibit mark, will come into evidence just like that they'll see in a video before, and then they come back to this. It's not the lawyer manipulative, whatever, voodoo magic, right? You don't want to be the trickster. The goal is to not look like I'm the trickster. I'm trying to catch you in a trap. The goal is to point it out in a way that makes a difference, right? Now, I get involved in cases all the time at different points. This happened before I got involved in this case, but I love it. This is one of my favorite things in the world in this case. After watching that video, after looking into the background facts, which I could go through, spend this whole presentation telling you all the things they did wrong. Well, this is what the director of the 30B6 of this company says, that this wasn't a preventable wreck, right? Well, I'll tell you what an Orangeburg jury does with how to teach them it's preventable is they take everything they got, so that way they know it's prevented, right? So they don't have to get on the interstate and worry that if they get stopped in traffic, somebody's going to do that to them. There's the quick way and easy way to prevent this in the future. If they don't recognize how to prevent it, well, I promise you the jury can know how to and figure out how to do it. But is that as effective as watching this person, kind of like present like this. And I'm not
You
telling you
did
it's
a
the best video
preventative
deposition.
analysis on this accident and determine whether or not this was a preventable or non-preventable accident?
Yes,
And what did you determine?
that it wasn't preventable.
I mean, look at her. She's smug looking. She looks like, I don't give a shit, right? I mean, that tells the story. Now, in a minute, I'm gonna show you how to do this in a deposition format, but I want to make sure I'm gonna show you a little bit about this program. You take this, designation wizard, and it's so simple. I mean, it's like creating a written designation you've done probably 100 times before if you try cases. And this pulls the video out for you, right? You go in the video deposition, you type this, and I'll show you how I do it if we get enough time. But basically, once you create your page line through page line, it'll generate these clips for you. And you can name them whatever you want so that you can use. And I know I use weird names. I drive every attorney I work with crazy. Even if you look at my program over here, it drives a lot of people crazy. But basically, it generates this. So this is a deposition involved in one of these, and this is one of the ones that pulled out from a video demand that is confidential, but I've marked out a bunch of stuff that otherwise couldn't come in. But you get in and they've seen it marked up, and they've seen like live while I'm doing it, I'm creating these annotations to it for the jury to focus on this. And I know that looks like a ton, and you're like, well, that's not useful to have that much annotation on one document. But think about it now. They're seeing these one at a time and working through why this is important. And I can always, in closing, come back in here and re-emphasize, certain things, and then one at a time go through, re-emphasize certain things live for the jury in my closing. And I can save these. You can put them in a PowerPoint. And again, you can do all this with the stuff that comes on your computer when you buy from the store. Maybe it's not as good as the OnCue, but it can do it with stuff that comes by from the store. You can focus in on what was a big part of this thing. Obviously, I think you can tell he lied about ever having, anxiety, depression, nervousness, or other mental problems. He denied suffering from dizziness, headaches, numbness, tingling, memory loss. He denied having sleep disorders. He's denied having sleep tests, right? Which obviously we had proof that not only, he knew that he lied on these and certified that, another slide would show you where he signed, swearing that this was true and accurate. And ultimately, we proved that not only he knew, but the company knew. But there's things, and this doesn't seem simple, but there's cases like this where you've got video. I mean, this looks bad, right? That looks like, damn, you got like rigid light bars down the side of that trailer from this video footage, right? I mean, this is pretty bad to think that anybody can't see that from a mile away, right? This is a case recently resolved, right? But I knew a jury was gonna have a hard time with that. So what do? This is my recreation. I went and borrowed I found exact stuff. I called about everybody I knew that was a truck owner and operated a flatbed truck like this, got people that had the exact same truck, exact same flatbed. And, do you think I wrecked the car? No, it's just simple. Set up some cameras, pulled up right to the car and went in reverse, but then flipped the video around, right? And, you look at that and you're like, man, there's a lot going on there. Why do you think that's ever going to be usable? Well, I'm not an idiot. I know how to call a conspicuity expert and get them to come set up the eye exposure calibration chart. I know how to go buy the exact same little Swan cheapo $130 but great infrared camera system to record. I know how to move the light so I can make sure they're the exact same height as the one. I know how to measure the height of the headlight to make sure there's no difference from what at the scene, and you've got this recreation scene where I'm live, recording it. So I've got the comparison that's got similar dimensions or exact same dimensions as this, where, you got the actual accident infrared camera showing, you've got, my infrared camera showing what it looks like so they can see how it jumps out at you. And then, you go into illustrating. Yeah, I mean, that on mine too, it looks like I got light bars down the side of that. Who the hell would possibly run into the side of that, right? But when you look at it, and what's important, calibrated human eye versus open camera is much different. And, you know, if I back it up, see, calibrated human eye doesn't pick up the reflection at those angles like even a normal camera is. And, you know, why did I do the 2 separate videos? Why did I do the other one? Because I knew I was going to bait them into hiring their own comp security expert, do their own recreation, do their own analysis of whether what I'm showing them is bullshit or right. And did they calibrate theirs with the human eye? No. But I had mine done, and I had a secondary video so that after they spent the money to fight, and, you know, we got, well, here's what it looks like calibrated. Why didn't you calibrate yours, right? Yours isn't admissible. Mine is. You know, it's useful, and it teaches them that there's going to be a price to play the game. Now, taking the deposition, you know, this is one that you've seen that my co-counsel did in that
But
case.
The video and the statement
You know,
tell a whole different story than what you told me earlier under oath. Would you agree with that?
Yeah, it does look.
this is very good testimony. The video doesn't match your story, does it? But now, what if you put his written story up here? What if you could see right up here if there was a big, you know, bar at the time of this that shows exactly what his story was? It shows exactly what you know he said that is different from today than it was yesterday, et cetera, you know, because these are great clips to use. I mean, I love them. I just wish I had them in a different format.
Yeah, if it's over 12 feet wide, you have to have an escort.
Yes.
Okay, and so if they're, on this particular day, there was no escort,
No.
correct?
And I mean, you know, bring out that policy. I mean, the reason he says if it's over 12 feet, you gotta have an escort. Bring out that policy. Well, where does it say that it's gotta be over 12 feet under your policy? Now we know it's over 12 feet, but where does it say it? You know, that comes into play a lot better. This is, and I'll show you if I got time, I'll show you more. There's a recent trial I did where I got in late and I got to take this deposition. And I'm not telling you this
The regional medical center record.
because anything particular here, but I'm marking as 5.
You know, if there's anything in particular, you want to review, but I want to just make sure, you know, we go kind of right here at the earlier part of it.
And while I'm doing this is I don't want the jury to think I'm tricking her. Like, there's tons of medical records, right? If there's anything else you want to look at, I'm happy to put it on the screen for you, ma'am. But I'm gonna zoom in and I'm gonna focus on very specific questions.
So down here, when I see this note of history of present illness, you know, I see like this 10/2/2019 at 10:11. That's 10 in the morning, right?
And I'm particularly trying to do this in a
You know
way,
roughly when Dr. West
setting the stage, right? This is an exhibit
Dr.
now,
West, talk to the patient, see.
and we're gonna go through, and I'm not gonna sit here and do this where you listen to this whole thing, so I don't have enough time to do it. But all these little exhibits that are being created one by one, you know, there's this deposition where I'm focusing on what a definition of boarding house is. And in the same section, you know, they can't provide personal care.
Area on the top, you see how the law defines personal care here, right?
And
Personal care, provision of this.
And again, I would then highlight and underline the very specifics. And this witness had already offered an opinion that this doctor had done right by discharging this person to boarding house. But the doctor's order says you gotta help her with her you gotta provide a regimen for medication, you gotta provide help with daily living activities. And he discharged her to a place couldn't do it, right? I mean, and you know, that is setting the stage, not so that I can sit here and put this up in closing.
Is the director of the boarding house.
These,
All right, the boarding house, can't provide any personal services, correct?
Correct.
And she says patient just released from the hospital yesterday. See that?
these were set up to use for impeachment purposes, right? If you look at my file, all of these very specific items
And
are
you-
gonna be
you agree
used
that someone in the decedent
for impeachment.
position-
And what I would tell you is it was very, I mean, I'm not sitting here telling you this just to like pat my back. It was very effective. The jury loved it. She'd say one thing, I'd hit a button and I'd play the video of what she said that differentiated. I mean, there was lots of good things. I mean, she blamed it on like, you know, basically too poor to get proper services kind of attitude. It was the most ridiculous nonsense, I think I've ever heard. But at the end of the day, it's not just for the trial. Had I gotten in this case before the mediation, I would have taken those clips. And not that I don't want to impeach the witness, not that I want them to withdraw the witness, but again, the decision maker, that I want to pay attention to the real issue in the case is the people that are affected and how badly they're affected. I'm trying to create a demand. I'm trying to ask for money. This is out of one of those video demands. Why did he see the stop sign when he said he did? Slowest he got was 4 miles an hour, and it wasn't until after the turn. He blew through 2 stop signs, 1, 2. Why is it so much better to sit here and, ask the question, why is this man overloaded? Is it because he's a bad actor? Is it because over 23 years of driving this truck, he's always overloaded, that the company knows he's overloaded, that it's been reported, they weigh and they have the tickets showing that he's always overloaded? Does that become a driver issue, or does that become a corporate issue, right? Why is it that they have wash policies and this counts for security tape that's supposed to flash at night? It looks like this, right? And why are there so many pictures that are in this video? And again, this would be narrated in the video demand, making very specific allegations. I've omitted certain things that are confidential in this particular case, but this is very moving to a decision maker, because let me tell you, I promise you the defense attorney didn't tell him that the picture looked like that. I promise you he didn't point it out in his review letter telling him what kind of value he needs to consider putting on the case. He didn't show him that picture. He showed him what he thought maybe was strong, some of the weak stuff, but he didn't focus enough on the weak stuff. He didn't focus on the punitive conduct, the deliberate indifference to what it means to carry 94,660 pounds on a trailer day in, day out, and what it means to have a driver that 24% of the time is speeding, that is hard braking 2 times before this, 197 firm braking, doesn't appreciate that, and ultimately doesn't appreciate that what it was going to mean, that of course we're going to put a PI to show video of the guy continuing to run stop signs in the night, the guy continuing to run stop signs during the day. And again, those were video clips. One of the things that really pissed me off one time in mediation is there's a defense lawyer, gave a presentation that wasn't on point, right? It just all over the place. Then he has the audacity to show me what the Orangeburg courthouse looks like, right? So now I just use it in all mine, right? If it's an Orangeburg case, I'm gonna make the demand, and there'd be a voice over this making the demand. You want to act like we don't want to go down here? We're ready to go down here. We got the full presentation ready for you. And I know I'm running out of time, and Kim, I'm way too long-winded on things, and I had so much more I wanted to show you. I didn't even get to a lot of it, so I'm gonna do it real quick. And Kim, bear with me. Don't get mad at me, but this right here is the new system I'm using. You see this screen here? This allows me to put something in this. This is using a Vibe canvas. You don't have to have the Vibe screen to do this, but the Vibe canvas allows me to let a witness live annotate, whether it be, I'm gonna circle this, look at this encroachment at the C4, look at this encroachment at the C5, right? It allows me to annotate it by whatever, drawing lines on it. I mean, obviously I changed the colors, but drawing whatever I want on this, putting a pen up and saying, I'm gonna circle this, right? I'm gonna come in here and highlight something or whatever, whatever it may be, I can draw, on it. And not only that, can I draw on it as I'm talking to the witness, but look, in another room, my witness can be over here and, have a screen that gives him the same access. So as I'm drawing it, it's putting up on his screen too now. I don't know if you can see this, but his screen does the same. Well, what if we go to another page of this and get a live one, and you've got a radiologist or an orthoped trying to explain, what this is. And, he comes in here and says at C4, we've got this encroachment, and at C4, he starts to write out here that, I've got, and again, there's a bunch of different ways to do this. You know, I can write it to text, you know, C4, change the colors, C4. You know, radiculopathy, and I'm doing a terrible job. I'm not as good as I'd be if I wasn't trying to rush so bad. But C4, you know, radiculopathy, you know, whatever he does at the, you know, at the arm, you know, and you know, he writes on there, tingling in the fingers is what you expect from that. Something that goes back to all the things the client complained about the day after the wreck or the weeks after the wreck that didn't know what was causing them. You know, all of these things, sorry, I'm not even putting it on the screen for you. All of these things, he can live annotate and he can put it in the, I went to a different page. I told you I wasn't going to do that, Kim, and mess up like that, but
You're
he
good.
can have, you know, all of these things live annotated and, you know, focused on while you're doing it, and it's saving it to the video because you're doing a similar Zoom video. He's remote, he's in Texas, he's in California, he's wherever he is, and you're creating a live exhibit that you got screenshots of these. You've got, you know, let's say, I'll tell you where you've got to have them almost, right? Like if you, let's say you've got a brain injury case, right? I mean, who in the heck out of y'all knows how to handle these brain injury images and explain what these things are, right? I mean, these things are very difficult to understand for me, but when you get a radiologist up here and that radiologist is also, you know, pulls up the same image on his screen, whether it be his laptop, whether he's got a touch screen like this, or whether you put him in a in a room with a touch screen with something like this preloaded. Well, he can come in here and he can mark this up and he can tell the jury what that is. You know, he can come in here and point to different little spots. You know, he can write out notes on here. He can do whatever he thinks is appropriate that again, to explain, you know, what this hemorrhage is, what this lesion is, what this, you know, you name it. He can do it and it's going to make sense to a jury. It's going to make sense because when they got lost in translation with all the different things that have been put before them, they have been able to come back to an image at the end of the case. They've been able to come back to something that makes sense to them. Something that again is going to be able to be used throughout the case, whether it be in your video demand, whether it be at after mediation, cross-examination of their expert. And it's going to be repetitive. And, you know, no, don't beat the dead horse like you hear complaints of. No, don't go in there and do the same thing over and over with the same exhibits created in every single deposition the same way. No, have one. And it becomes in every part of the case now what the jury's used to seeing. And when you put it up there, it's not tricky. It's not manipulative. It's giving everybody the opportunity to you know, put something else. If you got something else, some other way to explain that, why don't you do it in such a way that makes sense, right? And you're going to get better results. And I got so much more I want to show all y'all, but I'm way too long-winded and way too short with the things that I need to spend more time on. But this is my way now. Rather than just me having the pen, the annotating ability right now, like in the past with OnCue, I can annotate it while I'm asking questions, and some of my co-counsel laughs because I'm up there typing words on the thing. You know, why not let the witness do it, right? Why not give them the power of the pen? You know, and you know, you'll find that the jury and even, you know, everybody that looks at it is going to find it more credible. It's not you trying to do what he's telling you to do, even though it's better to do it the way he tells you to do it than just pre-do it, pre-annotate it. And then you got all your exhibits annotated, ready to go. Trial is a breeze because you've got it already organized into categories, topics. You've already done your designation wizard or whatever, pulled your video clips of your video, and you've got it organized into categories, right? And maybe you've got 10 witnesses on this issue of was this truck so wide that it needed an escort? Well, have 10 clips in there from 10 different witnesses where if they try to say, no, we didn't need an escort. Well, Didn't you say, didn't this person say this person say this person, this person, go through all 10 and then end on that damn policy. I mean, how do you beat that? Right. And it's not that complicated, guys. And I probably make it more complicated than it needs to be because I'm a dork, but there's stuff in your software that's native to Windows that you can do all this in. I encourage you to utilize it and think outside the box. Think about what's the next way that we're going to present our case, and do it early, do it often, do it before you get to that point where you're deciding, do I take what my client needs, or do I get them what they deserve? Because in the end, I want Kim to get more data points on what people deserve, not what they need. Because if some people are just getting what they need, well, it's like everything else. It hurts the other side too, because they don't get a proper evaluation of what people believe people deserve in a case like this. Somebody settled one of the other claimants in that case, that one you saw that video, and these are a couple different cases, all different ones, but that rear end collision like that, somebody else settled a fatality from that for peanuts compared to nothing. It's crazy. If I told you the financial stuff that's confidential right now, unless we go to trial, you would be shocked to think that if I told you the amount of money people put in their pockets from this company and how much other things they said that led up to this not being preventable, it would shock you. But thank you, Kim, for letting me go over. Thank you all. Hopefully,
You're good.
I
do have a question from someone. They're asking, this is Maria Lasavio. She's asking, what was the name of the canvas used to write on the MRI film?
So I'm using Vibe Canvas, which is free right now. I think they're saying like February 29th, they're like, oh, we're gonna have to make a little bit of money off this. Vibe makes the Vibe board behind me. They make a bigger one than this. This is a pretty portable one that I can use and move around to different places, or if I had to get somebody to take it to the doctor's office, so he's got a big screen. But again, you can put an app on your cell phone where you can live view it on your cell phone if somebody's editing it. You can take your laptop like I've shown you, and I can be editing it with my mouse. But the Vibe board touchscreen, it's pretty neat for a witness, because you can have, one of the issues that I've faced is, yeah, it looks pretty to have Zoom. You have me or the witness in the corner, and then you have the screen you're seeing. But it's a whole nother thing when you see the whole witness up there with a pen writing on it and annotating it, and just gives it. It's like the old school when I first started. It was like, oh, David, you too high tech. You can't be putting all that electronic stuff up there because it ain't real. They gotta have the paper. You gotta hand them the paper. Blah 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 blah. I don't tell you. You can probably guess who I'm mimicking. Those of you that know some South Carolina lawyers, but that isn't true anymore, right? The only thing that's true is that people don't like electronic stuff that you're playing like a game. Like, I'm gonna cut out this piece, but not the piece right before that explains that this doesn't mean what I say it means, right? That's the only thing about the electronic version of it that's different, and so just try to make it very tangible. But that Vibe Canvas, I love it. This is new to me now. This is what I'm gonna start doing in especially my expert depositions. I don't think I'd do it if it was like a paper intensive thing that I want to like zoom into specific lines and call out specific lines. I'll stick with on cue with that, and I'll do it, calling out line and stuff. But if it's images such as radiology images, if it's something highly technical, like some kind of drawings, like you did construction litigation and you need to focus in on a defect in like an architectural drawing, there ain't nothing better than that, I promise you, because they can edit it, and I can't be two places one time, but while he's drawing on it, I can draw on it. I can take that little circle back. What is this, doctor? And I can circle it. And then, he can annotate it and say, well, this is a herniation, or this is a lesion, or whatever it is. Right. And that makes it a lot better, because you're both interacting with the document and it's on video.
I love it. And it keeps your jury awake.
Yeah.
Neuro radiologists are brilliant and they have so much to say, but a lot of the ones that I've called live to trial have just been dry as toast. And I feel like I'm losing my people. But if you want them to sit up and look, put up a picture. If you want them on the edge of their seat, nodding their head, show them a video, right?
Yeah, let me give you a piece of advice. Do not give this to the neuroradiologist too far in advance because he'll draw on so much shit on it and try to get way too. You got to keep it a little bit, they're so above my head, and the average juror just like it's just too much, right? I don't need you to explain everything, but that big old weird spot right there, focus in on that. I mean, you don't have to explain every abnormality of this brain to realize this person's got a very severe brain injury, right? I mean, this is.
I used to have them use simple terms too, when they would like draw on, we used to have paper exhibits, or we would have positive groups, and we would have them, and I would say, what's this the size of? What can we do to help translate this for the jurors? Well, we found this tumor that was missed, but it's the size of a walnut, and that's what I'm circling here. But to be able to do this now dynamically has even a higher impact, I'm sure. There's another question here for you, David, from Michelle Mize, asking, can David send out a list of all software that he uses and recommends? Do you have a list?
Sure, I'd be happy to send that out, and I might send it to you, Kim, and you forward it to everybody. And let me be clear, like I am always, and like for instance, yesterday I was putting this together last night after work because I had coached a baseball team and I wanted to put together enough, and I put together way too much, but I even use like a new tool I never used before yesterday, right? I mean, it's not, there's so many native softwares out there for basic functions. Just be mindful if you're downloading something that is trying to put a bunch of ads in your face, be careful, okay? Ask somebody, hey, there's got to be it's free, but is it worth it, right? For some of these things that'll put other junk on your computer. So be careful with that. Speak to somebody about it, do a little bit of research before you just download a new app. But I'll send you the ones I have and ones I find myself using day in, day out, and I'll tell you the ones that I'm researching. Like there's a new thing, I haven't opened it yet, but somebody that saw me do this, it's a videographer that helped me mesh the day in the life with a video demand. He gave me this system that allows you to switch between different inputs simultaneously, where to explain it a little bit more, like if you had like multiple people addressing something, that you could give, like you could quicker create better video in Zoom, or like where your Zoom video was switching a little bit more integrated, and you could just have it pin one screen as opposed to having it bounce back and forth based on whoever's talking. I haven't tried it yet, so I'm not going to tell you about it, but I'm going to try it because it sounds unique and fun, but sounds like a lot of what if you're a tech person, handshakes that can fail, right? HDMI is notorious for losing what's called the handshake. And if you keep switching between HDMI inputs, sometimes I think you run the risk of it's not a matter of if it's going to fail, it's when is it going to fail, right?
That sounds like the advanced class. So
yeah.
It's good to start with some of these other things. This is a really good question from Everett Garner. I think that's you. How do you incorporate these concepts in smaller cases?
So, I mean, literally, I know it sounds crazy to videotape a deposition in a $25,000 rec case, but what does it cost to videotape a deposition? It's not that expensive. But where you can make it worth your while is it gives you the plan of attack, because I don't want to be cutting up. I don't want to spend more time. I mean, there's a law of diminishing return, but if I've got a $25,000 rec case and I take the video deposition, and after that one deposition, I've got video excerpts of the defendant that I can impeach him, and they know they almost want an empty chair over having their defendant there. Trust me. I mean, it's going to get the case. This can get you the 25, maybe even get you the 50 in South Carolina, where they want to pay the property too, because they're worried about the punitive nature of it with him refusing to accept liability. You're not going to use it on an admitted liability, $25,000 case where it's soft tissue, but whiplash. If you ever looked at radiological X-rays of whiplash, and to have someone explain, even if it's someone, a lower level doctor, about what straightening of the neck and what that causes, and long-term consequences, it adds a lot of value to your case. A whiplash case with that radiology, where you see, where if you actually pull it up, and I did this in a case actually on a no property damage $5,000 kind of med case, I was a drunk driver, but I mean, they gave 89,000 in actuals and $1 million, $1 in punitives in that case. And it was in a much more conservative venue. And, that's all I did was I had the whiplash and spent some time talking about, the effect of this whiplash. She was a pharmacist who spent a lot of time on her feet and just quality of life just due to this simple injury, right? Didn't even cause property damage, but it caused this whiplash. You would think you're not hurt because literally when I say no property, not even a scratch on the cars, right? It was outside of Williams-Brice, bumper to bumper after a football game in Columbia. But I don't think the jury would have come close to the 89,000 or whatever they gave in actuals if it hadn't been, it actually resulted in injury. And I could prove it. And I could show it. You could see it in the radiology. But so don't discount it just because it's a small case. And think of, it doesn't cost you anything to go take their production and annotate it and get it in a focused format where it's used for your benefit either. That just takes a little bit of time and your effort.
I'm constantly amazed at what our lawyers are doing with what I would consider to be fairly routine soft tissue cases and what they're doing to take them to the next level. In traditionally very conservative venues, they are doing a little bit of technology, not super fancy. They're whiteboarding the futures if they're having injections, things like that, and jurors are paying attention. So we're seeing much bigger verdicts in soft tissue anecdotally than we were before. And I think it's because you guys are upping your game. You're taking the small cases very seriously too, which is what our clients deserve, right?
Yeah, and that goes back to what they need versus what they deserve, guys. I mean, sure, if it's a soft tissue case, you don't need a lot because the meds there's not a lot of meds you're going to need. You don't need a lot to fix it because there's no real fix. But let me tell you, it's painful, it's aggravating, it changes your quality of life. And you know what? If it's a bad actor, if it's somebody that the act is, and the culpability is there and the acceptance isn't, they deserve a lot more than people want to give them unless they understand how you're going to present it. So keep that in mind.
Yeah, definitely. And when you're in the database, when you've got a slight or no property damage case, click those buttons and you'll be very surprised to see how big the numbers can be. It's very obvious that our jurors are not looking at items like that with such a critical eye as the people we're dealing with on the other side of the case. There's another question that popped up from Greg Hogue. Do you still hire a videographer for depositions or just record on Zoom?
In South Carolina, unfortunately, we got to. I think you could try to consent by parties, which I'm not a big proponent of, just because I think videography is such an important, or court reporting is such an important part of this process. I'm a big supporter of court reporters, and the way the regs read is, you have to be certified, and you're going to have someone who's certified as a videographer that can attest that it's a true and accurate rendition of the video, right? I mean, there's talk about some tricky stuff. You can do some tricky stuff with a piece of video. I can change some speeds and things and make things. I mean, you can really modify it. I know it sounds crazy, but it's important that you protect the the accuracy of the record, and even a video record, there's ways to manipulate the accuracy of it.
Okay, very good. I think we have covered all the questions. Again, David's contact information and mine are in the chat, so take a moment to pull that up. Mine's in there as well. For those of you who aren't yet subscribers to CaseMetrix, please reach out to me and we'll let you look inside our live database free of charge for 10 minutes. And during that time, you can look at anything you want to view free of charge on your screen. And remember, in addition to our core business, which is a settlement and verdict database, we have a team of highly experienced paralegals on staff who can take care of your medical chronologies, summaries, and demand letters. So reach out to me if you'd like to see samples of our work, detailed qualifications of our paralegals, and pricing information. My assistant, Eli, will be reaching out to you guys this afternoon, calls or emails. So if there's something in particular you want, let me know. David's going to send me a list of the technologies that he uses most, and we'll be glad to share that with you, a recording, whatever we can do for you. And let me just check questions one more time, see if we've got something else. I think we may. No, it looks like we have answered all the questions. Okay. Any other comments before we wrap, David?
No, thank you again. Appreciate you having me, and I hope that somebody, look, rising tide raises all ships. So y'all go kick ass, take names, and get what your clients deserve, guys. Thank you.
This was fabulous to see how you're getting the big numbers. I appreciate it very much, David. Take care.
Yes, ma'am. Bye-bye.
Thanks. Bye-bye.